On February 15, 2017, Oakland County deputies executed a search warrant at a home in Oakland Township, Michigan. The residence belonged to Joseph Sheely, a tenured business professor at Oakland University. The search followed anonymous tips alleging that Professor Sheely was hosting parties for students that involved drug use and underage drinking. At the time of the search, four young adults were inside the home, including an individual named Jacob Spencer. During the search, officers recovered ketamine along with 2 rifles and 1 shotgun. All of the firearms were unloaded. Just 2 days later, on February 17, 2017, Mr. Sheely was formally charged with 7 criminal counts. These included 1 count of possession of ketamine, 1 count of maintaining a drug house, 3 counts of possession of a firearm during the commission of a felony, and 2 counts of delivery of ketamine. One of those delivery charges was based on allegations that Mr. Sheely provided ketamine to Jacob Spencer. The case went to trial in January of 2018, with Oakland County Circuit Judge Cheryl Matthews presiding. Jacob Spencer was called as a witness for the prosecution. Before testifying, Mr. Spencer was granted what is known as use immunity. This type of immunity protects a witness from having their own testimony used against them in a criminal prosecution. In other words, it allows the witness to testify about potentially incriminating conduct without facing charges based solely on what they say on the stand. After Mr. Spencer completed his direct examination by the prosecution, defense attorney Neil Rocky began his cross-examination on behalf of Dr.
Cross-examine
Sheely.
him.
Mr. Spencer, you have been around people who have used narcotics, haven't you?
Yes.
And you've seen people who, in your experience, appear to be high, haven't you?
Yes.
Who appear to be under the influence of some kind of a drug or affected by some kind of a narcotic, haven't you?
Yes.
Can you look the jury in the eye and tell me whether or not you've taken any narcotics today? Prescription pills, anything of that sort? Xanax, opiates?
Yes, I have taken prescription pills today. I've taken...
When did you last take a prescription pill today?
This morning.
What time?
I'd say around 9 o'clock.
And what medication did you take this morning around 9 o'clock before you came to court?
I took Vyvanse.
Vyvanse. Vyvanse is an amphetamine?
Yes, I'm prescribed.
Vyvanse is for ADHD?
Yes.
The behavior, the way that you're communicating, and I'm going to speak to you, try to speak softly and have a dialogue with you, okay?
Okay.
The way that you're communicating now, isn't this the way that you've seen people communicate in your own personal life who appear to be high or under the influence?
Judge, I'm going to object to that.
What's the...
Judge, he can ask him if he's high or under the influence, but
I'm not to ask
he's
him.
asking him to evaluate his...
I don't understand the question.
Okay.
I don't understand how I could look at myself from a third-person view.
So well, first of all, so the prosecutor objected, Your Honor.
Say the question again, I didn't understand.
Yeah, sure. The way that you're communicating now, I mean, can you hear, I'll withdraw and I'll ask it differently. Can you?
Are you fine right now?
No, I'm not.
Okay.
This is the way that you normally communicate?
I don't normally communicate from a stand in circuit court in a case involving an older man that threw parties with underage people providing drugs. I'm nervous. If you're accusing me of being drugs, then you're doing a very bad job as an attorney.
Okay.
You should be asking questions that are actually going to help your client.
Okay, next question.
I appreciate that.
And now I'm angry, and I'm going to tremble my voice even more, not because I'm on drugs, but because I'm nervous. Okay. And you're intimidating. That's what you do.
Okay, wait,
it's not going to work.
Okay, just answer the questions. And then
that's my answer.
Okay, we'll just answer his questions and we'll get you out of here. Okay. All right. Go ahead, Mr. Rock.
Thank you, Your Honor. Today, you testified a few moments ago to the jury in response to Ms. Hand's questions that Joe has provided you with ketamine on prior occasions at his house.
Correct.
And you said it was almost, I think I wrote down, said almost every time you were there. You remember that?
Yes.
At the preliminary examination, that was when you testified before in district court. Do you remember that?
Yes.
And you took an oath at that time, is that right?
Yes.
And at the time that was closer in time to the events of February 15th, true?
Yes.
And you told the That time you were asked this question, and this was your answer on page 62. Approximately how many times had you ingested ketamine that the defendant gave you at his house? Your answer, it was one time. It was that night. Wasn't that your answer under oath at the preliminary examination?
Yes, it was.
Today you've told the jury something different, haven't you?
Yes, I have.
So, 2 times under oath, you've given 2 different answers. True?
True.
Both of those pieces of testimony can't be true, right?
Mr. Rockhind then moves to what's known in court as impeachment of the witness. He points out a clear conflict in Mr. Spencer's testimony. During the trial, Mr. Spencer claimed that he received ketamine multiple times. But during his earlier preliminary examination, given under oath, he testified that he had only been given ketamine once. That inconsistency is a big deal. Impeachment is the process of challenging a witness's credibility by showing that their story has changed over time. And under Michigan Rule of Evidence 801 D-1A, a prior statement is not considered inadmissible hearsay when 2 conditions are met. First, the witness must be testifying in the current proceeding and be subject to cross-examination. Second, the prior statement must be inconsistent with the witness's current testimony and must have been made under penalty of perjury, such as during a preliminary examination. When both of those requirements are satisfied, the earlier sworn testimony can be introduced to show that the witness is contradicting themselves. Because Mr. Spencer previously testified under oath that he was given ketamine only once, Mr. Rockhind was allowed to confront him with that statement. The goal was simple: highlight the inconsistency and undermine Mr. Spencer's credibility in front of the jury. Before we continue with today's episode, I want to take a moment to thank the sponsor of this video, Incogni. If you've ever searched your own name online, you might have been shocked by how much personal information is out there. Your address, phone number, and even your relatives' names can be easily found. And that's exactly how scammers get a head start. Identity theft, loan fraud, and stalking often begin with exposed personal data. That's where Incogni comes in. Incogni works to remove your personal information from hundreds of data broker websites, people search databases, and private directories. They don't just stop at the basics either. If you find your information on a specific site, Incogni's custom removals feature lets you submit the link so their privacy experts can handle it for you. I've seen how a single exposed record can lead to serious problems, from impersonation to financial fraud. Incogni makes the process simple. You approve it once, and they take care of the rest, sending verified removal requests and following up until your data is gone. Right now, Incogni is offering members of the ATC community a 60% discount when you visit incogni.com/court and use code COURT. If you want to protect yourself and your family from scams and identity theft, click the link in the description and get started today. Thanks again to Incogni for sponsoring today's episode.
I know you said to only keep this yes and no, but I'd like to explain that this isn't about the amount of times that I did ketamine at Joe's house. This is about, it goes beyond that. Like I've stated multiple times, I was very inebriated every time that I was at his house. I may have even been given ketamine without knowing it.
You've never told the police before in response to any question. Let me finish my question.
Look.
You'll get every opportunity, Mr. Spencer. I'm keeping my voice very calm. I'm going to give you every opportunity to talk as much as you'd like. But you've never before today in front of this jury made an allegation that somebody gave you ketamine without your knowledge. Isn't that true?
Can you please rephrase the question?
Yes. Until just now, you've never told the police or accused in a formal setting, in this case, Joe, of having given you ketamine without your knowledge, right?
Correct.
That's something new that you just told the jury now.
Well, maybe it was something that I didn't consider when I first stated that I only did it one time.
I'm sorry. I'm asking you, I'm moving on to another subject. You're here testifying in court. You understand that, correct?
Mm-hmm.
Yes?
Yes.
You've just made another allegation against Mr. Shield that he drugged you with ketamine without your knowledge. Isn't that true? That's what you just told the jury.
Yes, it is.
Never told that to any police officer formally, nor did you testify to that previously in this case.
I may have mentioned it before. I'm not sure. There were so many times that I talked to detectives.
You just told the jury a second ago that it didn't dawn on you to think about that. Now you're saying that you actually may have said something about that. Those are two different things, aren't they?
Do you want me to go back and explain myself?
No, I'm asking you a specific question, Mr. Spencer.
Yes.
So your testimony today includes a new allegation against Mr. Shield that you were somehow drugged without your knowledge.
I'm not saying that. I'm saying that it's a possibility. I'm not saying that that specifically happened. I'm saying it's a possibility, as in there's no way anybody's ever going to be able to know that. I don't even know that myself. I'm just saying possibly, and maybe I considered that when I just said that I took ketamine multiple times at his house. Maybe I considered that it's a possibility, but there's no way I'm ever going to know if it actually happened.
Wait a minute.
That's what I'm implying.
Under oath.
I'm not alleging him of anything.
Under oath, the prosecutor asked you on direct examination whether Mr. Shield, whether it had provided you with ketamine prior to, at the time she went to his house. She asked you that. It was a very simple question. Do you remember it? Do you remember the question and answer a few moments ago?
Yes.
And you said yes. And you said, almost every time I was there.
Yes.
And you're saying that when you told the jury that under oath, that you were thinking to yourself that maybe it was given to me without my knowledge? Is that your explanation for that testimony under oath?
Yes, it is.
Does that make any sense to you? That you would answer a question directly that he gave you drugs in the past, gave you ketamine in the past, but now when I'm questioning you, it's, well, maybe I was thinking of, maybe I was drugged and didn't know it. That's why I answered it that way. Is that really the explanation you want the jury to accept?
I don't know how else you would want me to explain this. I would appreciate if you could move on to the next question.
I'm sorry? You want me to move on to the next question?
Yes.
The questions I'm asking are, Mr. Spencer, pointing out from contradictions in your testimony. Do you understand that? So I appreciate you would like me to move on, but I'm sure you can appreciate that the judge will ultimately tell me when I have to move on. You understand that too, right?
Correct.
Okay. You want me to move on because it makes you uncomfortable to have to getting caught in what is untruthful testimony.
Well, there's a lot of these really small discrepancies, like how many times did you do this? How many times did blah, 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 that like, I didn't just like, this isn't like a test that I studied for. This isn't college. This isn't something that I think is like a huge deal. So when you guys throw all these questions at me and then throw it on the record, it's not something that's like constantly running through my mind every day, and I'm remembering all these little tiny little details and splitting hairs about it.
That's what I'm doing? You think I'm splitting hairs? I'm questioning you about the truthfulness of your testimony and contradictions, and you're telling the jury that that's splitting hairs. Is that what you're characterizing?
I'm giving my time trying to answer all of these questions to the best of my ability.
We'll get to the reasons why you're here later, okay? Do you understand? But I'm still going to put these questions to you. Is that okay with you, Mr. Spencer?
Yeah, ask another question.
Thank you.
Yeah.
You testified today that on February 15th that you drank alcohol. That's what your testimony was under oath just a few moments ago to the jury, right?
Correct.
You were asked this question at the preliminary examination, page 62, lines 18 to 19. Did you drink alcohol that night? Your answer was no, I did not. Correct?
Correct.
Again, your testimony today is different than it was at the preliminary examination when you testified under oath there, right?
Correct.
You told the jury a few moments ago in response to Ms. Hand's questions that she asked you about nitrous oxide. Remember those?
Yes.
She asked you about whether or not you asked you about cocaine being provided to you at Joe's house. Do you remember that?
Yes.
You said that Joe had provided you with cocaine. You said that that was your testimony on direct examination. Do you remember that?
Yes.
That's not true, is it?
Pardon me?
Joe never gave you cocaine, and you didn't do cocaine at Joe's house. That's a lie, right?
Please, can you please rephrase the question?
The question was confusing to you?
No, can you just...
Yes. You testified today that Joe gave you cocaine and you used cocaine at Joe's house previously. That's what you testified to today. You've acknowledged that. I'm putting to you that that is not true. That is a lie, correct?
That is not a lie. I did use cocaine at Joe's house.
Okay. On page 61, lines 15 through 17, at the preliminary examination where you testified closer in time, the question was put to you, did you partake of the nitrous oxide or the cocaine? Your answer was no. But I've heard and seen it at his house on occasions. Wasn't that your answer under oath then?
That may have been. I don't know. I haven't...
Both of those can't be true, Mr. Spencer.
Okay, so that was your answer at the preliminary exam, correct?
Yes.
Okay, what's the next question?
Both of those can't be true. What you testified to today to the jury and what you testified to under oath at the preliminary examination, right?
Yes.
So one of them is a lie.
I was lying about not using them.
You were
Because I
lying
felt
at the
guilty
preliminary
because-
examination.
I felt guilty because my dad was in the room.
At the preliminary examination, you were under, that's just so the jury understands that. You took an oath before you testified in the preliminary examination. Is that correct?
I didn't want my dad to hear that I was using cocaine.
You took an oath to testify to the truth at the preliminary examination in district court, right?
Correct.
You raised your right hand just as you did today.
Correct.
You looked, there was a judge there named Judge Nancy Karniak, right?
Correct.
You looked her right in the eye and answered the question, no. Isn't that true? And you're
Correct.
testifying now is that was a deliberate, intentional lie.
He said yes.
Isn't that perjury?
Well, he's
Yes,
not-
it is.
Okay, I'll rephrase it. You recognize that when you're under oath, you face the penalty of perjury, don't you?
Yes.
You understand deliberately and intentionally lying under oath for any reason is perjury. Do you understand that?
Yes, I do.
So you concede that you committed
Mr.
perjury
Rockheim
from your
then
own
impeaches
perspective.
Mr. Spencer
By your own
with
words, you
another
committed perjury at the
inconsistent
preliminary
statement from the
examination.
preliminary examination.
Yes.
This
Mr.
time
Rockheim
concerning
imp-
Mr. Spencer's cocaine use. During cross-examination, Mr. Spencer ultimately admits that he lied during that earlier proceeding. Based on that admission, Mr. Rockhind argues that Mr. Spencer's conduct meets the definition of perjury under Section 750.423 of the Michigan Compiled Laws. Under Michigan law, perjury is a felony offense and occurs when a person willfully swears falsely about a material matter while under oath. In this situation, Mr. Spencer acknowledged that he knowingly made a false statement during the preliminary examination while he was under oath. On its face, that admission appears to satisfy the statutory elements of perjury. However, despite how serious that sounds, Mr. Spencer would likely not face prosecution for perjury. The reason is that he testified at trial under a grant of use immunity. As discussed earlier, use immunity prevents the state from using a witness's own testimony as the basis for bringing criminal charges against them. So while Mr. Spencer's admission allowed the defense to severely undermine his credibility and portray him as an unreliable witness before the jury, the immunity agreement would likely shield him from any perjury charges arising from those inconsistent statements.
Inconsistency.
When the police entered the house that night, you were in possession of drugs, right?
Yes, I was.
And tell us again what drugs you were in possession of.
Xanax.
Xanax. How many Xanax pills were you in possession of?
2.
And you did not have a prescription for those pills, isn't that true?
That's true.
You understood at the time you were possessing that it was a crime to possess them, isn't that right?
Yes, I did understand that.
You understood that it was a serious crime,
Yes.
and you understood that it was a felony.
Yes, I did understand that.
So you knew that when the police entered into the house that night that you were committing a felony.
Yes.
You knew that you were committing multiple felonies if you count the number of pills you possessed. Isn't that true?
Objection, Judge. It calls for a legal conclusion.
I would try
It's
it.
true.
Yes,
I would try it.
sustained,
It's fine.
sustained.
I would try it. I'm asking questions very politely, Your Honor.
He is asking questions.
Wait, you know that's not true.
Well, I don't know. I resent that because I'm not. I'm not suggesting that I know that that's not true, and I don't like to suggest, you know me, I'm not suggesting anything.
You suggested to the jury that if you have two...
I'm asking a question. You know what, then I'm asking a question, and if I'm wrong about that, then I'm wrong about that, and I certainly will withdraw that.
All right,
So-
next question.
So I will withdraw that.
Mr.
Rockhind asked,
then asks Mr. Spencer whether he knew he was committing 2 separate felonies by possessing 2 Xanax pills. That question immediately draws an objection from the prosecutor, and Judge Matthews sustains it. Judge Matthews explains that the question was misleading because it incorrectly suggested to the jury that a person can be charged with multiple counts of possession simply based on the number of pills they have. That is not how Michigan law works. Xanax, whose active ingredient is alprazolam, is classified as a Schedule IV controlled substance. Unlawful possession of a Schedule IV substance is governed by Section 333.7403 of the Michigan compiled laws, which makes it a felony to knowingly or intentionally possess the substance without a valid prescription. Critically, the statute criminalizes the act of possession itself, not the quantity of pills possessed. So if someone unlawfully possesses 2 Xanax tablets at the same time, that conduct constitutes one offense of possession, not 2 separate felonies. For that reason, Judge Matthews sustained the objection. Mr. Rockhind's question improperly implied that multiple felony charges could arise from possessing multiple pills of the same controlled substance at the same moment, which is an inaccurate statement of Michigan law.
And when you agreed to testify at the preliminary examination, it was your belief that if you cooperated and testified that you weren't going to be charged in the case. Isn't that true?
Yes, that's true.
And despite whatever it is that you did, you believed at that time that you'll end up with no criminal prosecution and no criminal record. Isn't that true?
That's what I was told.
And who told you that?
That.
Ms. Hand, seated to my right and to your left. And despite whatever it is that you did, you'll end up with no criminal prosecution and no criminal record. That's what you're testifying to. That's what you just testified to.
Use immunity, I believe the term is.
And you just testified a moment ago that you were told that you'd end up with no criminal prosecution and no criminal record, right?
Well, no prosecution for the possession of prescription pills.
So that's more than use immunity. Use immunity means, doesn't it, as far as you know, that you just get to, your words can't be used against you. But you're telling us that you actually have an understanding that you're not going to be prosecuted at all for your felonies, right?
Correct.
Isn't that in part why you're in here saying the things you are about Joe, so that you avoid a felony prosecution and felony conviction yourself?
Correct.
You're a young person. You're 20 years old, you said? Yes?
Yes.
You want to have a career in the future, right?
Yes.
You have a lot to lose. Would you agree with that?
Yes.
And your participation or involvement in some kind of crime could interfere with that. Would you agree with that?
Yes.
You understood that based upon what you were being told, that if you talked about Joe, you'd be able to avoid being in trouble, right?
Yes.
1 year ago, well, so not 1 year ago, this was back in February 15th of 2017 is when this search of Joe's house took place, correct?
Correct.
And today is January 18th or 19th. 19th, Your Honor? 19th. Thank you. In that time, you have not been charged, have you?
No, I have not.
And there are things that you have, you did go down and talk to the police on March 1st of last year, correct?
Yeah, it was around that time.
You got a record deal the day before that, didn't you?
Pardon me?
Didn't you get a record deal? Did you get a...
That makes it sound like he's a singer.
No. Well, aren't you a performer, a DJ?
What does this have to do with...
We'll let the jury sort that out.
Are you talking about this case?
Yes, I am. Yes,
I don't
February
think this
28th of 2017, the day before you went down to the police department to talk about Joe, didn't you get a record deal?
Oh, you do mean like singing?
I think a DJ.
Oh, I thought you meant, okay, all right.
Didn't you get a record deal? Didn't you get a contract by a company that signed you? Didn't you, something you were proud of?
I'm confused as to why you're asking me this and
Well,
why you're
let's-
asking me to disclose personal information.
He's trying to ask you if you have a lot to lose.
So on February 28th, before you went, you talked to the police, you got a record deal. You got a professional
Yeah.
music contract. That was something you coveted, that you were proud of.
Yeah.
You understood that a criminal case and a criminal prosecution could interfere with that, didn't you?
Yes.
So the very next day, March 1st, that's when you went down and you talked to the police at the police station about Joe, right?
Yes.
Okay.
On January 24th, 2018, following a multi-day trial, Mr. Shailili was convicted on 3 counts: possession of ketamine, maintaining a drug house, and possession of a firearm while maintaining a drug house. The remaining charges from the original 7-count complaint were not sustained at trial, including the allegation that Mr. Shailili delivered ketamine to Jacob Spencer. On March 5, 2018, Judge Cheryl Matthews sentenced Mr. Shailili to a total term of 3 to 4 years in prison. After completing his sentence, he was ordered to be deported to Canada, his country of citizenship. This case illustrates just how heavily a trial can hinge on the credibility of a single witness and how far a defense may go to challenge that credibility. Over the course of cross-examination, defense attorney Neil Rockheim methodically walked the jury through multiple inconsistencies in Mr. Spencer's statements. Those inconsistencies included conflicting accounts of how many times he allegedly received ketamine, his admitted dishonesty about cocaine use, and his initial attempt to mislead police regarding his own possession of Xanax. By highlighting these contradictions and emphasizing that Mr. Spencer only began cooperating after receiving assurances he would not face charges himself, the defense argued that his testimony was driven by self-interest rather than truth. Ultimately, the jury acquitted Mr. Shailili of the delivery charges, including the count tied specifically to Mr. Spencer's allegations, while convicting him on the possession-based offenses. That outcome appears to reflect the jury's assessment of Mr. Spencer's credibility, shaped in large part by Mr. Rockheim's effective, though imperfect, cross-examination. Let us know in the comments if there's another case or courtroom moment you'd like us to break down next. Thanks for watching, and don't forget to like and subscribe if you want to help promote a more informed society. We'll see you in the next one.